Hello friends, and welcome to a brand new video on the channel Law for All. Now in this video we are going to be learning about section 6 of the Specific Relief Act of 1963, which talks about recovery of the possession of an immovable property of which a person has been wrongfully dispossessed of. That is, he has been dispossessed of his possession of the property in a course other than that of a legal course. So now, as always, before I begin with the video, I would like to point out that I have left some useful links in the description section of this video. So if you'd like to learn more on various topics under the Indian law, then kindly do check out the links given in the description section. Now let's begin with the video. Section 6 says that if any person is dispossessed without his consent of immovable property otherwise than in due course of law, he or any person claiming through him may by suit recover possession thereof, notwithstanding any other title that may be set up in such a suit. Now what this means is that if a person is wrongfully dispossessed of his possession of an immovable property without his consent, otherwise than in due course of law. So this part is important. Then if a person has been forcibly dispossessed of his property without taking recourse of the due process of law, then in such a case that person who has been wrongfully dispossessed of the property can approach the court and ask for his possession to be restored back to him. Now to give you a basic example, suppose there is a property which has not been occupied by anybody, and I see that the property is unoccupied, so I trespass into the property. I do not have any title to the property, so I trespass into the property, erect a small hut in the property and start occupying it, and I start residing in that property. Now the real owner of the property does not know about that property at all, does not know about my possession of that property at all. So what happens is that after a period of 4 years, the real owner is intimated by somebody that I have been possessing the property, and he enters the property and forcibly evicts me out of that property. He does not file a suit as against me for recovery of possession, because the law of the land in India provides that force cannot be used as against any individual. The principle of law also is that to protect one's property, any person is entitled to use reasonable force, that is to protect one's property. But if somebody has trespassed into your property and has been living or residing upon that property, then that person cannot be forcibly dispossessed. A civil suit or any legal action would have to be resorted to in order to recover the possession. So that is the rule of law in the country. So getting back to that example, if upon a property I trespass and I erect a small structure and I start residing within the property, and if after say 4 years the real owner finds out that I have been occupying the property and he forcibly dispossesses me of that property, then in such a circumstance I can file a suit before the civil court under this section and ask for my possession to be restored, even though I do not have any title, even though I do not have any right to that property. Now, as most of you must be aware, there is a concept of law called as adverse possession, which means that if a person occupies a property for a continuous period of 12 years without any disturbance whatsoever from the real owner, that is, if the real owner himself has been ignorant about the fact that that person has been occupying the property, or for that matter if the real owner has sort of acquiesced to that said person, the trespasser possessing the property, then in that case, after the lapse of a period of 12 years, the trespasser can claim to be an adverse possessor of the property, and that is how he draws title to that property. So that is one of the ways through which a trespasser can acquire title to the property. But now in the example that I have given you before, the said person who has trespassed into the property has been occupying the property only for a period of 4 years. So therefore he would not be in a position to claim title by way of adverse possession to that property. So in such a case, even though he does not have any title to the property, if he has been forcibly dispossessed of that property, then he can approach the court under section 6 and ask for the possession of the property to be restored. That is, of course, he has to be dispossessed of his property otherwise than in due course of law. That is, he should be forcibly drawn out of the property. If the real owner has taken some due recourse of law, if he has intimated some authorities, if he has filed say a case of trespass, and if through some legal action if that person has been dispossessed, then in such case the dispossession is valid, and the person who has been dispossessed will not be able to avail the remedy under this section. But if the trespasser has been forcibly evicted out of the property by using raw brute force, then in such case that person can file a suit under section 6 and ask for his possession to be restored. Now, no suit under this section shall be brought after the expiry of 6 months from the date of dispossession or against the government. So, a suit for recovery of possession will have to be filed immediately within 6 months from the date of dispossession. It cannot be filed after dispossession, after 6 months from the date of dispossession. Now, the day on which dispossession is to be calculated is from the date of knowledge. I mean, that is the basic principle. That is, from the date on which the trespasser gains knowledge that he has been dispossessed of the property, from that day onwards, the trespasser will have sort of 6 months to file a suit for recovery of possession. So that is how the period of limitation will be calculated. I mean, of course, if more explanation is required as regards this specific point, then kindly do hit me in the comment section and I will try to explain that better. Firstly, after the expiry of 6 months from the date of dispossession, and secondly, against the government. So if the government, even without using the due course of law, even without that, if the government forcibly dispossesses a person, a trespasser, against who has trespassed into, say, a government property, then a suit will not lie under this section. The government has been explicitly protected under this section by the legislature. Now, thirdly, no appeal shall lie from any order or decree passed in any suit instituted under this section, nor shall any review of any such order or decree shall be allowed. Then, nothing in this section shall bar any person from suing to establish his title to such property and recover possession thereof. Now, these are I'll explain these 2 points in detail. Firstly, no appeal shall lie from any order, which means that if any order has been passed here, if an interim order, a stay or an injunction is passed, then no appeal would lie. And if a final order or a decree is passed in this suit, no appeal again there also would lie, because this entire suit in itself has been construed to be sort of a summary suit. There have been observations that have been made by the court, various courts, which I'll get to in a minute. But the basic principle here is that the only question which is to be determined by the court is whether that person, whether the plaintiff has been dispossessed, wrongfully dispossessed of the property, and whether the plaintiff was occupying the property. So these are the only 2 aspects that are to be considered and nothing more. So therefore, hence the legislature has done this, has included this clause such that there is no appeal or decree from any orders which have been passed, because under this section only the recovery of possession in itself is permitted, nothing more than that. And only just because the possession of the property has been recovered by the plaintiff does not mean that the plaintiff would acquire any sort of title to the property. It in no way means that the plaintiff has acquired any title to that property. And the fourth subclause is that nothing in this section shall bar any person from suing to establish a title to such property and recover possession thereof, which means that, again, retorting back to the previous example that I've given you, if the real landlord enters the property and forcibly dispossesses the trespasser from that property, supposing that the trespasser approaches the court and files a suit under section 6, he files a suit under section 6 and recovers the possession of the property thereof. The court conducts an inquiry, accepts evidence, appreciates it, and finally decides in favor of the plaintiff, and the possession of that property is restored back to the plaintiff, that is the trespasser. Now, this does not mean that plaintiff / trespasser will have any right to the property. Only his possession momentarily would be restored, but nothing will bar the real owner, the landlord, the real owner of the property, to file a suit and recover the possession of the property thereof by establishing his title. So this is like sort of like an immediate relief that is granted to an individual who has been dispossessed of the property under section 6. It's sort of like an interim relief, whereby a person who has been wrongfully dispossessed of the property gets right to occupy the property. That is all with regards to this section. Now, as I've pointed out previously, the landlord will have the right to recover the possession of the property. Just because the possession has been given back, restored back to the trespasser / plaintiff by the court, does not necessarily mean that person will have title to the property, that person will gain any title to the property. The landlord's right will always be protected. Now, this section entirely has been made so as to make people adhere to the rule of law. That is, if any possession is to be recovered, it will have to be done in due course of law, and this section is meant to discourage people from taking law into their own hand. Now, let us get into some of the important observations made by courts in various judgments. Of course, the links to both these judgments have been left by me in the description section as always. So if you'd like to read these judgments comprehensively, then kindly do check out the description section. These are very sort of landmark judgments with regards to section 6, and some very important observations have been made, and I'm sure that it will be of much use to you if you go through these entire judgments. But I'll just read out the excerpts from these judgments so that you get an idea. Now, a suit under section 6 of the Act is often called a summary suit, inasmuch as the inquiry in the suit under section 6 is confined to finding out the possession and the dispossession within a period of 6 months from the date of institution of the suit, ignoring the question of title. So, as I've mentioned previously, the only question here under section 6 is whether if a person has been dispossessed wrongfully, and whether if the person was in, the plaintiff was in possession of the property. So that is the only question. That is all. So hence the period of limitation has also been confined to 6 months only and not more. So that is because if the plaintiff is diligent, then he shall be entitled to some remedies, and if within 6 months he does not file the suit, it is presumed that he has consented to the suit being consented to himself being dispossessed of the property, and is sort of acknowledged the title of the landowner. Secondly, the purpose behind section 6 of the Act is to restrain a person from using force and dispossess a person without his consent otherwise than in due course of law. So the entire purpose is to make people abide by the due course of law and not take law into their own hands. Now finally, this excerpt explains what is in due course of law means. Now, in due course of law implies that the right of the person affected thereby to be present before a tribunal which pronounces a judgment upon the question of life, liberty or property in its most comprehensive sense, to be heard by testimony or otherwise, and to have the right of the controversy by proof, every material fact which bears on the question of fact or liability be conclusively proved and presumed against him. This is the meaning of due course of law in a comprehensive sense. That basically means due course of law basically means that a person has to have a recourse to legal proceedings. That is, a person has to be able to, that is in the sense that if possession is to be recovered, then when the real landlord files a suit for recovery, the other person, the trespasser or the defendant as the case may be, should have the right to be heard, should have the right to lead evidence, and the system would have to be such that it appreciates evidence and finally pronounces a judgment. So basically a court. So therefore due course of law would imply that the proceedings would be held before a court, would have to be held before the court, and the court eventually pronounces a judgment to the effect whether if possession is legal or not. So that is all that due course of law implies. So these are the important observations that I could find. Links are in the description, so check them out. And well, that is it about this video. Now if you like this video, kindly do like it, share it with your friends, and subscribe to this channel for more such content. Until next time, this is Pritesh saying bye.